Bienvenidos. Welcome to the Instituto Cervantes London. I am Victor Ugarte, the director. First of all, I would like to thank all the speakers in today's debate, John Sorabji, Jordi Nieva, Esther Gross, and Luis Carreras, and our chair, Bénédicte Paviot, and of course our audiences, both here and the ones watching us online. Today we are streaming online, but also will be recorded and edited and uploaded in YouTube in 2 or 3 days. I would also like to thank the embassies of Spain and France, the delegation of the European Union, the Spanish Chamber of Commerce in the United Kingdom, the British Spanish Law Association, so the European Union National Institutes of Culture, the London Cluster, and the Law Society of England and Wales, this is your institution, for the support for this event. On this semester, with Spain assuming the presidency of the Council of the European Union, the Instituto Cervantes in London is hosting this debate on the differences and similarities between the English and EU legal systems. Here at the Instituto Cervantes, we decided that a project like that brought British and EU citizens closer together would be the best way to link our cultural activities to the Spanish presidency. During this presidency, we have organized activities related to music and arts. Today's event is very appropriate given that the Instituto Cervantes London is located in Temple, which is one of the main legal districts in London and a notable center for English law. As many people are visiting us for the first time today, let me briefly introduce the Instituto. The Instituto Cervantes, created in Spain in 1991, was to promote the Spanish language and cultures of Spanish-speaking countries. Our head offices are in Madrid and Alcalá de Henares, the birthplace of the writer Miguel Cervantes. With a network of over 90 centers in 4 continents and more than 200,000 students every year, the Instituto Cervantes organizes Spanish courses, the diplomas for Spanish as foreign language, the DELE, teacher training, and many cultural events in collaboration with other organizations. Representatives from the worlds of academia, culture, and literature from Spain and Latin America direct the work of the Instituto Cervantes. In the UK, we work closely with British museums, galleries, theaters, publishers, and universities, as well with Spanish and Latin American organizations. We have an extensive library and organize extracurricular activities for students of schools and universities. That's it, thank you very much, and let me now give the floor to Bénédicte Paviot, Correspondent for France 24 and Chair of the UK Advisory Board of Reporters Without Borders. That will be very busy these days, unfortunately. Thank you very much.
Thank you, Victor. So, welcome, bienvenidos a todos. Those of you who are joining us in person, thank you very much indeed for finding us. And those of you joining us online as well. And my name, as Victor said, is Bénédicte Paviot. I'll translate that for you, Bénédicte Paviot. I am half French, half British, mostly in my career at BBC, television and radio, and I'm UK Chief Correspondent for France 24 in French and English around the world since its creation, some 16 years. So our debate, which promises to be fascinating, is entitled English Law and EU Law, Still, emphasis on still, 2 separate worlds. But it does have a question mark after it. So we have an eminent panel of speakers. We have 2 hours together to discuss the differences and the similarities between the English and European Union legal systems. So what is the role of European Union law post-Brexit? Yes, she used the word within 1.5 minutes of standing up in an introduction. Let's get that elephant in the room. So how good is the dialogue between judges in the EU and the United Kingdom? Interestingly, as I've learned, thank you, Victor, along the preparation for today's debate, the dialogue between judges in the EU and UK has some progress, I think, a little bit to make, because I've learned that it is Spain and France, so far only, that have made the clear choice of facilitating close dialogue between judges by providing the UK with a liaison magistrate. I'm not suggesting there isn't any other, but it's interesting that it is France and Spain. We're lucky enough to have Estelle Cros, who is on our panel, who is here from the French embassy and who is indeed France's liaison magistrate. I think we have the Spanish liaison magistrate here. Thank you very much. I look forward to hearing from you a little bit later on. So I think that is quite telling. Now, as the British media reports almost, we have to say, on a daily basis, that the UK government is planning to rewrite almost 4,000 EU laws. And civil servants, as we speak, are estimated to be spending tens of millions of pounds establishing which laws and regulations could, operational word, could be scrapped under the government's controversial retained EU laws bill. We'll explore the current reality and the future. So our other distinguished speakers joining me on the panel at the end of the line there, Jordi Nieva-Fenol, full professor, chair of procedural law at the University of Barcelona. Then, there, smiling, we've got Luis Carreras del Rincón, professor of procedural law, Spanish lawyer who comes a great deal to the United Kingdom. He's an expert witness in Spanish law in UK courts. And finally, our keynote speaker, John Sorabji, Dr. John Sorabji. That's the last time I call you doctor, but I might call you John from now. And you're an associate professor at UCL. Is it unfair of me to point out, and also, that you've been recently helping our King Charles, with some advice until I think as recently as 2 weeks ago. Now, our location, you alluded to it, Big God, could not be more pertinent, because here in Temple, this part of London is famous, whether it's British literature or other things, for its legal connections. Indeed, the area is brimming, as I think this room is, with barristers, well, not chambers, but barristers, solicitors' offices, legal institutions, and I'm told that lawyers have lived and worked in the Temple since the late 14th century, which is quite extraordinary. I was reading up a little bit earlier and I hope to do that again. It's absolutely fascinating. So before we begin in earnest, may I remind you, though most of you will probably have done this, switch off your mobile phones or put them on silent. There's always one person who digs into. Thank you for digging into your pockets and checking. And putting on silent, I appreciate it. I think I've done that with mine. So this is how we're going to proceed. We're going to hear from the four speakers, then we'll have a Q&A. So we've got 2 hours to compare and contrast English law and EU law. So to start, I propose, with our first speaker, Jordi Nieva-Fenol. You're going to talk to us about and kick us off with judicial proceedings in common and civil law, searching for common bases. Thank you.
Good afternoon, ladies and gentlemen. Well, as you will see, I'm not going to make my presentation in English, but in some version invented by me of the English language, but I hope it will be understandable for you. Well, in fact, I have to tell you, just to start with, it is my first time here in England, and I've been invited in many countries in the world, many also in Europe, but not in Great Britain. And why would you tell me? Because you don't have sufficient friends, you don't have enough links to universities. Well, it is not really for this reason. It's just that our two systems, our two judicial systems, are considered to be too different. That many people think that we don't have nothing to say of the English judicial system, because it's the same thing the other way around, because not many English people come to Spain invited to speak about procedural matters. So I think we have a kind of separated worlds that don't really correspond with reality, and that's what I'm going to speak about. In fact, our judicial processes, both British one one and the European one, so to say, the European ones, so to say, well, externally, they seem very different. They seem very different because, in fact, they have somehow different faces. I will speak about that very plainly. Don't worry about that. You will understand everything I say, I hope so. And, well, when you approach to those systems, then you see that maybe they would not be of much help to solve our Europe problems. But if you start reading the American literature or the English literature about procedural law, then you are going to find many common things and many things that have influenced our procedural law in Spain, and not only in Spain, but also in many other countries, especially in France, and from France to other countries, and that's what I'm going to speak about. First of all, even if both processes seem very different, in fact, they are not. They have the same origin. They have a Roman origin. And they have been influenced by some old Germanic peoples that came to our territories. This is the thing that maybe some English jurists think they make them exclusive because they were influenced by the Anglo, Normans and the Saxons and the Jews. But we were influenced by the Visigoths and also by the Arabs and also by all other German peoples. And the Italian procedure was influenced by the Burgundians or the Lombards. So they were also Germanic peoples. And they also had a Roman procedure there. But the question is, in Spain, or in Europe in general, it is very clear that the Roman procedure remained after the fall of the Roman Empire. But what happened in England after 410? Well, in fact, these are the dark ages or the dark years that we have not many information about them, but we have many hints that some kind of Roman procedure with a jury in trials was held between that year and more or less the Norman conquest. That's 1066, as you all know. So the system remained, and this is what, or something of that, this is what we call common law, jus commune. And this has a Roman origin, of course, with the other influence I told you. But these were the same influence in every other corner of Europe. And after that, after the Roman contest, there was a big battle of the Norman kings to produce law, as you all know. They wanted to change the laws. In fact, this was not only an English problem. This was also a problem in France, in Castile, in Spain, in any other part. So the king wanted to create law. They found different solutions. For instance, in Spain, they took up the Visigoth law, the German law, and said, this law says that the king is the source of law. This is perfect. The king can do what he wants. What did they do in England? In England, well, I mean, they are very much more diplomatic than we are. And then the king created a new court. That's the court of chancery. And they were called to resolve the matters in equity. So not according to common law, but according to what they called equity. That was in fact a copy of the difference between law and equity that you can very easily find in Aristotle's works. It's the same difference. They took up with this. And after that, was there any other influence from Roman law? Well, it really was, because the judges that were working in the court of chancery, they were educated in canon law. And canon law is very much influenced, about 98% for Roman law. So the Roman roots are really the same. And to be honest, and it is very risky to say this here in English, I would, in England, I would say that maybe the Roman procedure is more, the English procedure is more Roman than the continental procedure. And I'm going to show you why. How was the Roman procedure? The Roman procedure consisted in two phases. First phase, it was the phase in iure, what you say. And the second phase, it was the phase apud iudicem. Maybe this rings some bells to you. This may recall you to the pre-trial and the trial phase of English procedure, because it's really the same difference. And you say, no, it's impossible. English law couldn't take up this from an old Roman procedure, now 2,500 years old. This is impossible to happen. So, how was this Roman procedure? 2,500 years ago. Well, in the first phase, they had the so-called praetor. The praetor was a judge, in fact. And this judge had enormous powers of directing the matter in this phase. So, this praetor decided how was going to be the procedure. If he himself was competent, if the matter had another procedural problems, they fixed the facts to be discussed in the second phase, and they were also ordering the evidence means to practice, to celebrate in the second phase. And of course, this praetor, this judge, could end up the matter there in this first phase, because he thought that the parties didn't bring all what he wanted, I mean the evidence, or that the positions of the parties didn't have any prospects of success. And maybe this also rings some bells, because they are the same or almost the same competencies that the English law gives to the judge in the pre-trial phase, with a summary judgment and with all the orders that this judge can give to the parties, and especially to the solicitors of the parties. And this English law comes, if I'm not mistaken, from 1998. So it's very modern. You see how history repeats itself. But it's not really that history repeats itself. It's like a continuity in history with just some waving movement in the powers of the judge. So if the judge has to be more active, or if the judge has to be quieter. So, is this very different from continental procedural law? What did we do? We also had this pre-trial phase. Our judges were not so active, but it really depended on every judge. So you cannot tell that they were inquisitor or they were not. You really had to know every procedure in every country to be sure about that. And the doctrine doesn't go so far. So we can imagine that they were not so active that it was a thing of the parties to discuss this pre-trial phase. But the phase existed until it came a law in Austria that was very influential all over Europe. It was a law of 1895 that made this phase to be really summarized and concentrate all the evidence efforts not on the first phase, but on the second phase, that means on the trial phase. Do we have a trial? Because as you know, trial in England is really long. It takes long to make all the interrogations, because they follow the method that you normally use for the juries. The juries no longer work usually in civil procedure in England, but they worked. They were active there. So they follow the same method to do things. Do we do the same things in continental countries? Of course not. We don't do that. And if we do something like that, it's just because continental lawyers and judges have seen American films. And they copy what they say. But we also have a trial. It's not so long, just because we didn't have juries. And do we have, just to end up with my time, do we have any other influence from English law? A really genuine influence from English law, because up to now I have been talking about Roman law, as you see. Do we have a direct influence from English law? We really have. And I'm sorry to tell that until 3 years ago, more or less, we thought that it was a French influence. But it is not. France was influenced by the appeal in the House of Lords. And they really copied that. The Assemblée Nationale recognized that expressly in their acts, that they were copying the English system. I don't know why someone did hide that before and afterwards. I don't know, because it has remained uncovered until 3 years ago, when I discovered that acts of the Assembly, and I saw that the first written document to speak about cassation, it was a paper, it was a document directed to the French king that was written in 1767. And this was thought to be a genuine French document. But in fact, in England, there was a masterpiece being published by that time in 1765, 1 year and a half before. And this was the masterpiece, very well known, of William Blackstone, Commentaries on the Laws of England. And really that document, if you read Blackstone and you read the document, you see that it's a summary of the positions of Blackstone about the work of the House of Lords. And this was really surprising. And as we took application in our rules, we can say that we have some English institution in our procedural systems. Well, I think we will have time to discuss with each other. I only said the most astonishing things I wanted to say, just to open up the discussion. So I thank you very much for your attention.
Thank you. Well, thank you for that travelling journey through history. I was peering over to Estelle, France's liaison judge, and just checking, and under my breath said to her, "Tu savais ça? Did you know that?" Lo conocía, and did you know that?
No, I didn't.
Well, there we are. My premise is always that not only do we want guests to learn from them, but that our speakers should learn from each other. So you've already accomplished that, for which I thank you very much indeed for kicking that off in somewhat of a surprising, and congratulations. Perhaps we could have blown it. This is your first trip to England?
Yes.
Perhaps we could compliment him on that. We're gonna ask
Academical
questions
trip,
later.
it was here as a tourist, of course.
Yes, but we will have the Q&A later. We're going to have our Q&A. Thank you very much indeed. I will be sure to call on you later, but do put your hand up when we get around. Sorabji, for now, thank you very much indeed. That was fascinating. I learned a lot from that. So now we're going to move swiftly along so that we can get to the Q&A when we need to. And that is with Luis Carreras del Rincón. And you're going to talk to us about bridging the gap between common and civil law.
Looks like.
Yes, stepping into big shoes there.
Good.
Go on.
I'll get the flat on stage.
Yes, do. Always a good idea.
Well, thank you.
Oh, it's actually, are you not hearing us properly? Is that it? Because it's actually, okay, well that's an important thing. I see somebody has very kindly just gone out to the technician. It's a modern system that should hopefully pick up, well, not hopefully, picks up everybody's voice. So I will encourage the speakers, you can hear me, can you, clearly?
Yes.
Okay, so I'll encourage the other speakers to speak at about roughly the same volume, and I'll take out my metaphorical whip, if I may.
Good.
I'm sorry, I'm known for being quite strict about talking about that. If I
Yes.
need you to raise your voice.
Okay, I will.
Okay?
Promise. Good afternoon. Thank you. Honored to be here. First time in Instituto Cervantes. Thanks to the director Victor, and thanks to my learned colleagues. And I'm just a lawyer. You know, they are really wise people in terms of law, but I just practice it. But that's my contribution today to this panel. A bit of experience in the field of law. If I may, at the beginning I will just consume 2 minutes explaining why I am here, or what the expertise I have that allow me to be here and share with you some of my experiences. Otherwise, you will think, who is this guy coming from Barcelona who claims to be a lawyer? Well, 1987, I got a scholarship from the British Council, so that's the beginning. It was 6 months studying, getting a flavor of English law, very close here, the King's College. And then I had a sort of practice time with a solicitor and a chamber of barristers. That was my first connection with English, with England actually, and with English law in particular. Wow, it was so different. Everything looked so different when I came here. And it was different in many aspects. At that time, I had the chance, I was lucky to follow, literally follow a barrister, Lord Anthony Lester, who died already, and one very young Baron David Panic, who was still practicing in this. He was very young at the time. Well, I could go with them to even to the House of Lords once, to a court hearing, I mean. And I started learning from these guys, colleagues. You know, I was just a very young Spanish lawyer. I had 3 years of practice at the time. Well, later on, I had the chance to be part of a legal team working in a case here in the House of, here in the Queen's Bench Division, just at the other side of the corner, with a barrister who later on, Lord Irving, who later on, not very late after that, he became Lord Chancellor with Tony Blair. So I had the opportunity to talk to this, to be part of that team with this excellent barrister. Then afterwards, I got some instructions like that one to be part of different, as expert in Spanish law in different fields of law. Generally speaking, it was jurisdiction. So we were, the Spaniards who were trying to get the jurisdiction on that case to Spain, normally unsuccessfully, because the English courts used to think that this couldn't be a better place to decide a case, which is in fact, in fact, probably true, generally speaking. And one of those judges was Lord Mance, who later on was deputy president of the Supreme Court. I remember very well the time I had to give evidence in his court, the questions he put to me, the intelligence and the brightness of the I will speak about that later. But he did want to understand what I had to say. Later, a few years later, I had the pleasure to collaborate with Alexander Layton, QC, who is now a deputy High Court judge as well, and he had to work in a book called European Civil Practice. And I had the chance to write with him, or he wrote with me, the Spanish chapter of the legal system, explaining the legal system. But it was about after 2010, when those of you who know what Rome II is, made me work a lot here, and I'm still doing, although this is about to end. Rome II, for those who are not familiar with, is a EU law that permits that if you are a British citizen, you have an accident in Spain, or whatever in Europe, wherever in Europe, you may go back home, sue whoever you have to sue in Spain, in France, or whatever, and then the English judge will apply Spanish law. That is my case. And that was my role, to come here and explain the judge what the Spanish law was regarding that particular case. And that was thanks to Maria Louise Kinsler, KC, today KC, in a very famous case in this regard for those who participate in this sort of litigation, Bacon versus Nacional Suiza, Queen's Bench Division, just around the corner. The judge was Stephen Tomlinson, later Lord Justice of Appeal. But I had the chance to see very good professionals in this. Well, after that, I've had more than 150 instructions on different cases, some with colleagues here. So what sort of, this gives me then the chance to give you like two sides of the coin. One is what do we have very different, and what do we have in fact not that different or even similar. It goes far beyond that thing that, solicitors and barristers, but in Spain we have also two professions, procurador, legal professions, procurador and abogado, but it's nothing to do with that. You cannot use that, it doesn't help at all to explain what do we do there and what they do here. Far beyond that. If you put now in a position, for instance, if you are the legal head of the legal department of the insurance in Spain, insurance company, and they get, after 2010, the first claims from London, and they know nothing about the legal terms or how it comes, how it is here. They learn quickly that it is very expensive to litigate here, much more than in Spain. And then they find themselves lost, to the point that some of them at the beginning, they asked me would you please come to my office and explain to me what's going on in England? Because we are lost, desperate, disorientated. And yes, I had to, and then I did, obviously, with pleasure. And I had to go there and tell them, for instance, the first difficulty they have is the risk. What's the risk I'm having with this litigation in England? How much do I have to pay if I lose? No idea, not yet. We have a claim, yes. It may be a lot of money, yes. How much? We don't know. Yet. Oh, so if you're an insurer, you do not know the risk, you have a heart attack. In our system, you know from the very beginning the claim that you have, and the evidence that we provide, etc. So you can balance and see if you can say, okay, we better settle this, or we better fight it. No idea. No, I don't know. Then the evidence. No, at the beginning they would say, but they don't have any evidence here with these particulars of claim. There's nothing. Say yes. Well then, how can they win this case? My friend, this is just the beginning. The risk will be, let's say, portrayed, will take form as long as the evidence is moving through the procedure in England, and then one day you will know the risk, because you will probably have a sentence that will have to pay a lot of money, plus interest and costs. And second, the evidence will come with experts, my case for instance. And then also the third question was the legal cost, because they are always concerned about, any company that has litigation is concerned about how much will this cost to battle. And they say, well, say, I don't know, I can't help you with that. I know that it's going to be a lot of money. I mean, the longest the case is, the more expensive it will be, and potentially a lot. And you have to know that you will probably have to pay the other side's costs as well. Sometimes even if you win. I mean, that's amazing. And finally, they asked me, well, can we settle now? Can we do something to settle now, as soon as possible? No. Why not? Because the system is not thought to be settled at the beginning. It takes a while to discuss the case, to develop the evidence, to agree upon or disagree upon the facts and the law, and then at the end, one day they will settle. And actually, most of the cases I've been working with or giving experts in written expert reports have been settled before the trial. But at the very end of this long race, a lot of legal fees as well. So no, don't worry. I mean, do trust your lawyers in England. They know what they do. They are not crazy. It's just another game. Okay. Even I discovered that here, at least the first years, the solicitors, the barrister who used to instruct me, they had a formula, mathematic formula, to decide whether it was worth to settle beforehand or to go to court. Because if you calculate the risk you have of the potential amount of money that you have to pay, and you put on top the potential cost of the litigation, of the days in court, then it is better to give up a bit of your right and pay more, because it's going to be cheaper than paying at the end of the case, even if you have some right, if your arguments were right. I don't know if I can explain that properly. So it's that thing. So when I told them this, they said, okay, well, at least I know I cannot relax, but at least it's like if you go to a doctor. There's nothing worse than when the doctor says, I don't know what you have, but we have to make some analysis and things like that. So at least they relaxed and said, well, similarities. And then I start the good side of this, because when I had to explain all that, I said, calma. Good news. The parties are equal. So you have the right to defend that. You will have the right to produce your evidence. You will have the right to have your good lawyers, and the insurers have the money, so they tend to hire good solicitors and barristers. So they have, and me as well, which are for my personal, let's say, interest. Having the party who is instructing you is the one who's got the money. It's always useful, because I'm going to be paid for sure. Yeah, but it's true. Okay, we have parties and there's a battle. We have to battle on facts and evidence and that. But what I experience here is the sense of justice that I have felt here. I have to say it politely. But sometimes I have felt it here more than in my country. The way the judges deal with the case is not always as good as here. Or let's put it in positive. Sometimes the big experiences of sense of justice I have experienced in England more than in Spain. And I've litigated all my life in Spain, 40 years. That's a good news, I think, for those who live here. Because the judge wants to know. My experience, when I've been cross-examined and the judge has decided to ask directly questions, you see that the judge wants to know, to give a fair, just decision. He wants to know. And at least though, in those cases I have been cross-examined, which are quite a few. Oh, where's my timetable? My Benedict?
Yeah.
Good, I'm finishing.
Yes.
And in particular, in these cases I've been working, the judge, let's say, in Spain, if you have an accident, by law, when you have, the judge has to decide which compensation you have to get to compensate the body damage you have experienced. There's something that we call a baremo. It's a sort of guide that is mandatory. It's the only country in Europe, as far as I know, where there is a guide that the judge has to use to decide how much money your arm or your kidney or your eye is worth. Well, the English judges, they really want to use the baremo because they know that in Spain it's mandatory and they want to know and really make an effort to understand how it works. And when they see that sometimes the baremo is unfair, which is very often, because it is devised to pay less. That's the truth. So that even when the judge here sees that the part of the application of the baremo is, in economical terms in England, unfair, the judge does do that. But if there is a way to lean towards the weak party, they use it as well, because they are human beings. No? They want to be fair. And I'm finishing with that, in order to do that, the main similarity in practice is the precedence system. An English judge, we know, I'm not talking about how obligated is an English judge to decide according to the precedents on the same case. In Spain it's different. But in practice, what the judge wants to do is say, well, what has the Supreme Court said in a case like this? Or the Court of Appeal in Spain, have more than 50. And they really want to know. And then my experience was that the better I explained the judge what the case law has been in Spain, the better he understands and the better he decides, according to my point of view. Because if you put a lot of doctrine or, I don't know, other flavor on that, which other experts were keen to do at the beginning, the judge gets lost. While if in my expert report was, look, I'm not going to decide for you, Mr. Judge, but in Spain we have this case, as many as I can, with this approach, these solutions. So I give you a range of solutions, and then you take the one you think fits to this particular case. And it works, because the judges doesn't want to be fooled, neither in Spain nor here. No? So they expect you to be very fair, open, and to be able to work, to help them decide, not to tell them what do they have to decide. Well, and the last thing is that litigation in Spain is unfortunately, very in general, as slow, although slow is a subjective term, but it's as slow as here. So we are very similar in this respect. So you know that it takes time, it takes effort, but at the end, if you have the right and you choose the right counsel and lawyers, and then you only need a judge that wants to give you justice, which is usually the case. Well, thank you for listening to me.
Thank you. Well, that's a very interesting contrast in the different realities. We had the history that we've had. Also, thank you for your humour, and I think we can say your honesty and possibly your diplomacy in trying to explain to those of you who are Spanish that possibly things are done slightly better. better here. She muttered. Now we move on swiftly to the liaison judge from France, Estelle Cros. Thank you, Estelle. Do you need your glass of water with you, maybe, or are you fine? You're going to be fine. Okay, and you're going to talk to us about, interestingly, what a lot of people actually aren't familiar with, but of course in this room will be, retained EU law and the heritage of EU law in the British judiciary. And you said, a new hybrid law? Question mark?
Question mark.
Yes.
Thank you very much. Many thanks to the Spanish Embassy in the UK and the Cervantes Institute for organizing such an event as part of the Spanish presidency of the Council of European Union. Gracias al Instituto Cervantes por aguardar. I'm sorry because I don't speak any Spanish, so that would be only my Spanish word.
You need to come to the Instituto more often.
And I was very pleased to hear my predecessor, because sometimes people ask me, but what is your job as a liaison judge? And I may answer, I'm trying to plug a PC and a Mac while plugging a French court with a UK court, but I'm not talking about this subject today. I've been asked to talk to you about retained EU law, and I think one of the most complex questions is the role of European law post-Brexit. So also the UK has formally withdrawn from the EU at the end of the transition period on January 1st, 2021. The EU law is no longer a source of directly applicable rights within the UK, but this by no means implies that EU law has no role to play even today. A new source of sui generis law was introduced by the European Union Withdrawal Act in 2018 and named as retained EU law. The UK Parliament has wanted to ensure continuity and legal certainty post-Brexit by adapting EU law and is applied at the end of the Brexit transition period into domestic law to some extent. Law professor and barrister QC Duncan Fairgrieve compared retained EU law as a kind of Polaroid snapshot of EU law as it stood at the date of the 21st December 2020, and which is thereby introduced into UK law as of that date, in some circumstances as it already existed within the UK law. So in the Act, in the 2018 Act, this Act established three categories of retained EU law. There was first category was the domestic law, mainly the regulation, statutory instruments that was implemented or related to the former EU obligation and including directives. The second category was the EU legislation, which was directly applicable to the UK. For example, at this time, the General Data Protection Regulation 2016. And the third category was other rights and principles of the EU law with direct effect in the UK. And let's say, for example, the Article 167 of the Treaty of Functioning of the European Union, which required equal pay for male and female workers. In the last 2 years, leading up to December 2020, the British government, enacted hundreds of pieces of domestic secondary legislation, making around 100 changes to the body of EU law that is now considered as assimilated law. In fact, the written EU Act, enacted on 29 June 2023, aims to facilitate the amendment, repeal, and replacement of EU written law by removing the special feature of EU law attached to it, and now provides a legal framework for the interpretation of written EU law by the EU courts. So I had a question when I prepared this speech, and my question was, the EU Written Act, is it a new paradigm shift? The semantic shift that renamed retained EU law to assimilated law reflects the fact that the interpretative effect of EU law will no longer apply to this new body of legislation, now integrated into the national legal heritage. Beyond the normative integration or divergence of EU law into national legal corpus, there's also the essential question for a judge of the future of the CGEU case law, including that established before the end of the transition period. Apart from the fact that the CGEU has jurisdiction after the end of the transitional period to deal with issues arising from the withdrawal agreements, such as disputes concerning citizens' rights or the Northern Ireland Protocol, does the case law of CGEU still constitute a jurisdictional heritage for the British judges? American jurist Benjamin Cardozo has evoked the image of the judge as a mason. So, regarding this image, the judge can place his brick on the right foundation of the bricks laid by his predecessor. So the question is now for the British judges is whether they can regard EU case law as solid bricks on which to build, or will they have to create new methods of construction? How should the UK judges interpret assimilated law? To what extent will it diverge from the assimilated case law? How will it take into account of national case law established in the light of the interpretation given by the European Court? The European Union Withdrawal Act made it clear that the UK courts were to interpret the retained EU law in the light of Luxembourg cases already in existence on January 1st, 2021. Nevertheless, it allows the UK Supreme Court and Scottish High Court of Judiciary to differ according to the same criteria as the Supreme Court in deciding whether to depart from its own previous decision, and the threshold is namely when it appears to do so. There has been very little jurisprudence on this point, and I just want to quote one case is the Tuning versus Warner Music cases 2021, in which the British Court of Appeal refused to diverge from the European case law. The Master of the Law, Geoffrey Voss, said it would be both unnecessary and undesirable for this court to depart from retained EU laws in this case. To do so would create legal uncertainty for no good reason. Now, the Retained EU Act clearly restricted the role of the EU law and case law developed before the end of the transitional period. The Article 5 of the Withdrawal Act has already clearly established the principle that the supremacy of EU law was no longer part of national law. The Retained EU Act clarifies that the supremacy of EU law is no longer part of national law after the end of 2023, so very soon, regardless of when the underlying provision in question was adopted. So it's a big change in the Act. Any direct EU legislation retained must therefore be interpreted as far as possible in a manner compatible with national law. The interpretation by UK courts may also diverge from general principle of the EU law. Now, the Article 8 makes it easier for national courts to depart from the EU case law. The Act also established a clause number 7, which is very, very important for the British judges, because it established a new criterion for higher courts, so the Court of Appeal or higher instance, to decide whether or not to depart from the EU case law. And they have changed the threshold. It won't be the threshold that the Supreme Court can use. And now the higher court must take the following 3 elements into consideration to diverge from the EU interpretation. The first criteria is the fact that the decision of a foreign court are not binding. The second one is any change in circumstances relevant to the EU case law adopted. And the third one is the extent to which the selected EU case law restricts the proper development of national law. So I find the last criteria extremely interesting because the notion of good development is not defined within the Act and would leave judges a great deal of latitude. That's also a criteria, to my point of view, that clearly reinforce the vision of primacy of national legislative sovereignty. The British government also considered that British courts should have greater freedom of development case law and EU written law in force and don't have to be limited by the influence of pre-existing EU case law. In other words, courts are encouraged to deviate more from the retained case law. Some commentators consider that this freedom of the judge will lead to the modification of a large part of law in a very short time and would be source of unpredictability. Another article is very interesting when we compare English law and maybe the EU law, is the Article 7 of the Act, who create a mechanism that could be inspired by the EU preliminary question. Actually, the EU Written Act provides a very interesting mechanism, enabling a lower court to refer point of law arising from written law case to a higher court if it's considered a point of law to be general public importance. So the higher court rules only on the point of law and refers back to the lower court to apply the legal ruling to the facts before it. This mechanism, which is directly inspired by the European preliminary ruling, is part of an interesting trend towards dialogue between judges at a national level, Court of Appeal or Supreme Court, and at a lower level on the interpersonal of European case law. In any case, there's still a great deal of uncertainty as to what the British court will or will not do in relation to the European case law. In any case, British judges will have to have a considerable power, and there will be and some commentators and some politicians that maybe it's give too much power to the judges. It's also likely that British courts will continue to recognize the European judgment, even if they are not legally binding. The dialogue between judges, pioneered by Lord Bingham, also no longer institutionalized with the European Court. I think it's destined to continue. And what have said Lord Bingham is very, I think, relevant in this time. He said, if a decision handed down in our country offends the primary sense of justice, and if it emerged from consulting for foreign case law, that most courts would adopt a different but more acceptable solution, whatever the tradition to which it belongs, that should command us to review our position. In a shaky world, there is a virtue in adopting identical solutions, regardless of the diversity of the paths by which they have arrived. While the British judges' dialogue with the European Court has been a dialogue of authority when we talk about primary ruling of an imperative nature, maybe can exist other different types of dialogue, such as a dialogue of persuasion, or a voluntary adherence, or a dialogue of genuine sharing. Judges are developing increasingly close relationship with each other across border. The relation can take many different ways, many different methods. I would say quoting foreign judgments in their decision, exchange of argument, joining training course, having dialogue between jurisdiction, creating a transnational association, and I think the British-Spanish Lawyer Association are joining us today. So in this respect, I really think that each member states and the European Union have a leading role to play in maintaining the UK's place in European bodies for a judicial dialogue. Spain and France have many years ago adopted dialogue between judges by providing UK with a liaison magistrate as facilitator of mutual legal assistance within the legal framework of the trade and commercial agreements. Spanish and French liaison judges are also involved in the day-to-day dialogue with the British judges. As a privileged partner of the European Union, the UK is always present as an observer to the European Judicial Network or the European Judicial Training Network, and as Eurojust, but also Europol, for example. And I was wondering if today we could imagine European liaison magistrates in the UK for the future. Let's hope for the future that the UK position in the bodies involved in European judgecraft will be maintained and even strengthened for the benefit of the citizens of a Europe that defends democracy and the rule of law. Thank you very much.
Estelle, thank you very much indeed for the clarity with which you explained that. I think it sounds like there needs to be a lot more liaison in the French sense, and also the way the word has migrated into and its definition in English all round. So it'll be interesting to see how that pans out, and perhaps some of that will come up or not during the questions. As for a European liaison magistrate, that's a very interesting one. You heard it here first. We'll see what happens to that. It's interesting also, and that's one of the many purposes of today's debate, is to stir these kinds of ideas, because it's very important to be thinking of that now, as you said. Big changes coming at the end of this year. And now, our keynote speaker, no pressure. John Sorabji, yes, you're going and you've chosen to entitle your keynote Continental and English Civil Procedure, Differences Without Distinction.
Always go for a snappy title.
Yes, absolutely.
Whether the presentation matters
Soundbite
or not.
as we speak.
I know, is exactly
Exactly.
the thing. Thank you very much for inviting me today. It's a pleasure to have been invited to speak this afternoon to mark particularly the Spanish presidency of the Council of the European Union, and also to have been asked to talk about English and Welsh civil procedure, the law of our courts, as well as the courts and the law of the courts of our neighbours on the continent. And friends as well on the continent, not just neighbours but friends, because the two don't always go together, notwithstanding what we're going to say. So my overarching theme today, though, can perhaps be best summed up by something that, and I'll choose an English poet here, that an English poet, Alexander Pope, said. And those words, which you may well be familiar with, were that no man is an island entire of itself, every man is a piece of the continent. Our various civil procedure codes, the laws of our courts, do not and cannot stand alone. They serve the same purposes. They have intertwined, if not common origins, and they adopt many techniques in common to achieve those purposes. And where they differ, they provide, or at least I hope they provide, what they call in America laboratories of learning, hopefully inspiring better rather than best practice amongst all of us. So in my presentation today, I particularly want to highlight 4 points with those things in mind, particularly that we are all a piece of the same intellectual continent. And those points are, first of all, commonality of purpose, secondly, commonality to a degree of origin and development, thirdly, where there perhaps was a slight parting of the ways as history has gone on, and finally, I want to look at reasons why we might consider that our various procedural systems may actually grow closer as time goes on, and that perhaps Brexit is not the parting of ways, but actually just one more part of a much longer story of cooperation and common development. Now, before I start that, I should say that Georgie and I wrote our presentations entirely in isolation from each other. We swapped them, it was either last night or the night before, And tellingly, we highlighted a number of common themes. We picked the same examples, thankfully. Georgie went first and didn't use all of the ones that I was going to use. Otherwise, but actually, maybe you should have done, and then I could have had a quite short keynote. But there we go. But I think the fact that we came up with similar points actually is quite telling in terms of the fact that we do have a great deal of commonality. I was quite interested to hear, for instance, he didn't tell me this the other night, that the king is the source of justice. Well, we would say here the king is the font of justice, or the fountain of justice. So exactly the same type of idea historically there. So, first of all, let me look at common purposes. Now, if I can refer to Jeremy Bentham, as we're in London and he is up the road, he said that civil court rules at their simplest can be seen as little more than the means by which substantive law is given effect through ensuring the identification of right fact, the application of right law in respect of those facts in a court judgment, and if necessary, hopefully unnecessary, the effective enforcement of any such judgment through enforcement mechanisms. Now, it's often said in England that we do this in our courts and we do nothing more than that our courts are there to resolve individual disputes. They're entirely focused, solely focused perhaps, on the parties and their individual dispute. This is a point that writers have made, particularly scholars who've looked at English civil procedure over the years, particularly Jolowitz was one of them. Looked at from a different perspective, it's also sometimes said that procedure in continental Europe, in the French or the Spanish, etc., procedural systems, may go wider than dispute resolution and focusing on the individual parties, that perhaps it has a wider role in terms of implementing social policy, for instance. Goes wider than the parties. Now, I'm not sure that that's true for either of us. We are both our systems, and I'll use the word both here, both our systems, all our systems are focused on resolving individual disputes, focused on the parties. Equally, we could say that all our systems, equally here as anywhere else, are focused on implementing social policy insofar as it's instantiated in law. So the courts are there in terms of vindicating rights, explaining the substantive law, etc. They have the same type of focus. So the idea that perhaps we have a narrower purpose here in just focusing on individual disputes, and that may not be necessarily the case elsewhere, is, I think, incorrect. We both have the same multiple purposes in terms of what we do. And I think our systems go wider than that, because they don't just focus on the parties and they don't just focus on the law in terms of interpreting it or explaining it or applying it. What they do through their judgments is provide the mechanisms through which we prevent disputes arising, and equally through which we can ensure that disputes are resolved without going to court. They provide the socio-economic, the legal framework through which individuals can order their affairs without resort to court in ways that they know, for instance, that their property rights, property transfer is secure. They know what will happen if they breach a contract. They know what their obligations under a contract are. They know not to be negligent when they're driving cars, etc. So all the aspects of the law, as it happens as it's applied in court, through judgments, the availability of that information, that knowledge, that promulgation of that knowledge by the courts is a key way in which we go much beyond the role of dispute resolution. And that is the same whether it's through the doctrine of precedent here, through jurisprudence constante in France, through the position that was outlined earlier of picking the right Supreme Court judgment in Spain to make to help the lawyers, but not just help the lawyers, but also to guide citizens, to guide businesses. So we have those same purposes. So, common purposes. So what about common themes? Now, we can see common themes in terms of implementation of those common purposes. And interestingly, when we talk about the ways in which our civil procedure systems, the law of our courts, implement, give effect, I should say, to substantive law, we sometimes mask what's being done by the use of terminology and also by the use of our histories. So to give you some examples, if we're looking at similarities between our systems in how we achieve accurate decision making so that both the courts and individuals outside the courts know what the law is. I refer to the Court of Chancery. Thankfully, Geordie has led the way here. Now, one of the things that he didn't tell you when he mentioned disclosure or discovery, one of the differences that we have within English civil procedure and procedure on the continent, is that actually, and it has to be said with a quiet tone, it is very often believed to be the single thing which differentiates English civil procedure from everywhere else. It is unique in a sense that it was created by the common law, and it is definitely English. The Americans borrowed it and did something else with it, but it was English in origin. Well, the truth is, it isn't English in origin at all. We borrowed it. We borrowed it from a form of canon law procedure called the Denunciato Evangelica, which was a form of mechanism through which the canon law courts could obtain evidence to what was described as scraping the conscience of the parties to ensure that court decisions, the decisions of the judges in those cases, was absolutely correct. So you ensured that the information was provided. You compelled the parties to tell you the truth in terms of their documentary evidence. Not English at all, borrowed entirely from the canon law procedure. And then we can also say, and again, it pains me to say this, but another aspect, another key aspect, which is said to be, something which marks out English civil procedure from what happened on the continent. We have the writ. We see the words writ referred to in newspapers still. Somebody issues a writ against somebody. So the mechanism through which you issue proceedings, the newspapers still refer to writs. They were abolished in 1999, but of course, we still refer to them. But the writ is the historical mechanism through which we commence proceedings here. You can't think of anything more English in terms of English procedure as the writ. But where did we get it from? Did we create it here? No. This, I'm afraid, is not canon law procedure, though. No. We got this from France.
Sorry, what was that?
From France.
Oh, yeah. Just checking.
Right. So it was an import from 1066. It comes from Norman civil procedure. And if you look at some of the case reports, insofar as they exist, from the years after 1066, on this side of the channel and the other side of the channel, they talk about exactly the same mechanisms. It's the same thing. So we borrow and we pretend it's ours. So you might say that English procedure, or at least historically, was something of a magpie. It borrowed to see if things worked. And when they worked, yes, it's ours now. So we have a common origin there. And of course, I won't labour the point, but it's always nice to hear, as Geordie outlined, that the House of Lords, the Supreme Court now, is the origin of cassation. That was a wonderful piece of research, I have to say. But again, only because we're passing back, having borrowed in the first place. But again, you see, we're not just having similarities in that sense, we're actually learning from each other. So it's that laboratory of learning. We're seeing what works and we're using what works. And that's very much an aspect of our history. And again, that was 1066 and all that. We can come closer in time to see similarities. So one of the points, again, that Geordie thankfully made was about case management, was about managing proceedings. Now, generally here, when we think about managing proceedings and case management, what we think about is what happened in America in the 1950s and the 1960s as case management was introduced there. Common law system, introducing case management, giving judges power to manage cases. Well, if we just peel that back a little bit, when we go back to the 1820s, in the 1820s we thought about introducing case management, but it was decided that the reasons to introduce it was to make, of course, litigation quicker and cheaper, well, and make the courts more effective to do that. But the courts decided it wasn't their fault that litigation wasn't quick and was expensive. And it was the fault of lawyers. It's always the fault of lawyers. So we didn't introduce case management then. But we tried to in 1870, and it didn't work. We tried to again at the turn of the 1900s, and again it didn't work. We tried again in the 1960s. and it didn't work then. In 1999, we introduced it properly, and we introduced unacknowledged, I should say. We introduced a type of system that was introduced effectively in Austria and Germany at the end of the 1800s, which was inspired by Franz Klein. So we did exactly the same. So again, we learn from what goes on in the continent, but again, we don't really seem to acknowledge it, which is quite interesting that we don't. But there we go. We got there in the end, 130 years later, but we followed where Europe had led, where continental Europe, I should say, had led, and we got there.
Good distinction.
Yes, no, that was a slip of the tongue, and not a Freudian one, I have to say. So there we go. But in terms of case management, we do have there is a distinction, because in Germany or in Austria, for instance, you don't just manage the process. Case management goes beyond that. It manages the substance as well of the proceeding, so it manages evidence. You can call this substantive case management. We don't yet have that. I say yet. We don't yet have that. But not so long ago, I think it's around about 5 years ago now, a slight tweak was made to our civil procedure rules, particularly applicable where one or more of the parties isn't represented by a lawyer. And this little tweak allows judges to, for the first time, not to give, as Rolf Stirner puts it in terms of Germany, hints and tips to parties about what they may want to do, what evidence they may want to produce, they may want to find, what steps they may want to take. But the court can now alter its orders to reflect the fact that individuals aren't represented, so it can provide assistance. And that assistance could, in principle, in theory, go towards helping them identify questions to ask, areas to look at in terms of evidence, but not as far as managing it in the way that occurs at the moment in some civil procedure systems on the continent. But it's a first step. And you never know what's going to happen in 5 years' time or 10 years' time. You know, once a first step has been taken, if it works, if problems don't arise as a consequence of it, if we learn and continue to learn, then perhaps we will go along that line as well of development. So possibly. And again, just to bring it properly up to date in terms of similarities, we also have the development of the promotion of alternative dispute resolution, which all our courts do now. Now, we've done that here through pre-action protocols since the late 1990s. They have not yet been introduced, into our continental friends system, although I think that Norway is looking at the prospect of that. But what we have seen, not least through the promotion of the EU ADR directive and ODR mechanisms, that there is an overarching promotion, which of course we were part of and continue to be part of through developments here, that we have this similarity in terms of the expansion of the role of the courts. So not just resolving disputes through adjudication, but helping the parties resolve their disputes through helping them to reach a consensual settlement as well. So again, we have a similarity there, all arising at the same time. Interestingly, we will shortly be following Italy in terms of mandatory pre-action mediation for certain types of claims, for small claims, similarly to the position in Italy. I imagine that will be introduced within the next 6 to 12 months. The government has certainly indicated that that is going to be introduced. So we will follow where Italy and other jurisdictions have gone in that direction too. And hopefully we will learn from them in terms of effective implementation. Because it's always a good idea to learn from others when they get there first, not least to make sure that you don't replicate the mistakes that they make. And of course we all make mistakes when we do something first. And the real question is how to make sure you learn and don't replicate. So, those are kind of common themes. I think though in the future, and this is where perhaps I kind of I'm going to strike out slightly in terms of getting a crystal ball out. It might be thought, notwithstanding retained EU law and its sui generis nature, it might be thought that having left the European Union, that the development of English and Welsh civil procedure may diverge. So we may have had historical similarity, commonality, we may have had common themes historically. But now that we've struck out on our own, it may well be thought that we're going to diverge, or at least not follow. And of course we then diverge indirectly as developments occur on the continent. It may even be thought perhaps that we will strike out in an Atlanticist way, and that we will start to develop our systems based on the approaches that's taken in the United States. And of course, we are common law jurisdictions, so why not? I have to say, I am very sceptical of any idea that the system here is going to become more like the US system. The differences between our systems are so manifold that it would require such a change over here that our systems would become almost entirely new. So, for instance, as is well known, the US civil litigation, the civil jury is alive and well. We have no civil juries, apart from in a vanishingly small category of cases. So would we reintroduce the civil jury? No. Manifestly far too expensive and far too time-consuming to be introduced. Would we introduce the deposition? That development, that uniquely American development of discovery or disclosure? No. There's absolutely no way we... Well, I can't imagine any potential world in which we would introduce depositions, not least because we don't need them. Because in the United States, depositions operate in a way that they do because of the nature of the pleading process in the courts in America. Our pleading process operates differently. There's no rationale to introduce something to cure what you might say is a lack in the pleading process. So I can't see us moving in an Atlanticist way. But what I can see is increasing commonality between our development here and development in European civil procedures in the law of courts in Europe. Now, why do I say that? Well, I say it because 2 years ago, a document was published called, and its full title is the Il Unidroit Model Rules of European Civil Procedure. Snappy, you know, it's a title that really gets you going. But what it does is it sets out a common procedural code which is based on and devised from looking at and analysing all the laws of all the courts of Europe, so not just the European Union, but of all the European countries. So, and it sets out best practice. In disclosure, I was one of the people who devised this, so you might be sceptical about me plugging it, but I'm not plugging it because I'm saying it's good, I'm just plugging it because I'm saying that it may be the basis for increasing harmonisation as time goes on. And I say that not because of wishful thinking on my part, but because it's already been used in Norway to help them revise their appellate court rules. It's already been used by the European Commission in terms of reforms of the rules on service of process. It's being used here by our Rule Committee, as we've been told on a number of occasions now, by Sir Geoffrey Voss, who's the head of our civil courts. So it's being used to influence here, it's being used to influence in other countries. In France as well, it's been used, I think, to influence the drafting of the commercial court rules. Yeah? I'm glad I got that bit right. So it's already having a wide influence across European countries. So if we're going to all be revising our systems based on a common template, a common frame of reference, we're going to inevitably move closer together. And when we think that we're also at that stage in time, where we're revising our systems to digitize them, we're at the point in time where we're all actually actively working to revise our civil codes, our procedural codes, in a way that we have never done in the past, i.e. simultaneously. We're all working at the same time through a common medium to revise the way we approach civil procedure and the law in our courts. So we have the impetus. Has this common frame of reference arrived at the right moment to help us draw together in our design and our redesign of our systems? Quite possibly. I'll put the crystal ball away now, but there's a possibility. And I'll leave you with one thought. And it's a thought that comes from an attempt to draw us together in terms of civil procedure that was carried out in the 1990s by Marcel Stormer and a group of academics who were asked by the common market, as it was at the time, to devise a common set of rules for courts across Europe, the Stormer Project. And one of the things that Marcel Stormer said, and it draws on the line about Masons, one of the things that Marcel Stormer said was that his task, the task of his working group, was like building a cathedral. They were all cathedral builders. Now, of course, cathedrals can be built in lots of different ways, different styles. You can have Gothic ones, you can have Unitarian ones, austere ones. And one of the things that I like to think about, as I tie this back to Spain, is that you could have one cathedral which looks like the Alameda in Madrid, perfect, beautiful, austere in its magnificence. And then you can have the Sagrada Familia in Barcelona. And the Sagrada Familia is still incomplete, I believe. Yeah? Yeah. So you can see one cathedral as a complete work of art. You can see another one as an ongoing endeavour. And I think that our civil procedural rules, whether here or in Europe, in continental Europe, are that ongoing endeavour. And I think the interesting thing is for our future is that we start off from a common base and there are spires coming up from it. And each of our systems is one of those spires. And each is incomplete. And as we move forward in time, I think the design possibly of those spires is going to become more and more common in terms of its beauty, in terms of its simplicity and commonality. And I will leave that as my final point. Thank you all very much.
Well, thank you very much indeed. Interesting that analogy again of a mason, I think. Living next to a cathedral, I can relate to that a lot. And it is a very interesting concept, the difference between Gaudi's Sagrada Familia. Thank you very much for that. Are we going towards increased harmonisation? So now we come to the Q&A. So we've both we're going to have questions here with you in the Instituto, and then of course we welcome questions to come online as well. Just before I come to you, sir, I'm going to tie that as you aspire to tie it up as beautifully as you did. May I invite José Miguel García Moreno, who is the Spanish liaison magistrate to the UK. I think you wanted to ask a question of our panel.
I just want to ask a question of the panelists regarding one issue which I think is very distinctive in the common law legal systems and civil law legal systems. And that has to do with the system of appointment, selection, promotion of judges. This is clearly different, although in some of the systems in Spain we've had an evolution in the latest years to approach it somehow partially, we would say, to the system in common law. But I think this is very distinctive, also in the way the judges deal with cases and deal with the parties and so on. And I would like just to invite you to make a reflection regarding that issue, which I think is quite interesting and relevant probably for the audience.
Okay, gosh, I assume that was directed to me. I suppose the classic difference between the appointment and promotion of judges here is that we haven't historically had a career judiciary. Our judges are drawn from the legal profession, generally from quite distinguished members of the legal profession who've reached a certain level of skill and experience over a number of years. We don't go straight from university or from doing law exams to a career track, and we don't go to a magistracy school such as exists in France or in Italy, and I assume as well in Spain. Yeah. So there is that historic difference, and I don't see that changing because that would require a fundamental change in the organisation of our judiciary, and also a fundamental change in legal education and also in the legal profession. But there has been, I think, over the last probably 10 years or so now, a change, and it's still a very kind of nascent change in terms of the idea of a career judiciary. So what we've seen over the last 10 years are individuals appointed to the, I'll say lower, but I don't mean it in a kind of pejorative way, a lower level of the judiciary, district judges, part-time appointments, etc. So the age of that, so therefore the experience of those appointments, is coming down. And we're seeing more and more of those individuals who are appointed to those posts gain promotion, so moving up to the next rung in the ladder and the next rung. Now, historically, if you became a circuit judge, for instance, so the senior judge in the county court, you would have no expectation of becoming a high court judge. Now there are a number of former circuit judges or high court judges and even I think we've had some that have gone up to the Court of Appeal. So we're starting to develop, subtly and incrementally, a form of career judiciary, but not to the same extent, and not from the beginning of careers, as in continental European systems.
So that's a continental influence, in a sense, or not?
No, I actually don't think that is a continental influence. Although we've learned, I think we clearly have learned from those type of systems, and particularly we have a judicial college which has been established for a very long time now, which doesn't go anywhere near as far as in terms of the organisation and structure and funding, etc., of the magistracy schools, etc., in continental systems. But I think there has been some learning, but I don't think there's a direct influence. But I think there has been some learning. Well, I know for a fact there has been some learning because of exchanges between some of the judges here and judges in particularly Italy, and visits to the judicial magistracy school there, and particularly, the judge who used to be in charge of it, Raffaele Sabato, there was communication. Let me put it that way. An influence, I think, comes through that communication.
And that is fascinating, because whether it's the legal profession, the medical profession, the journalist profession, in the end, sometimes there are individuals who can help promote that learning and that sharing. And I would just offer up, as somebody who's moderated EU conferences and other conferences, one of the things I've learnt the most in whatever field it's been is that actually that sharing, rather than seeing each other as rivals and competitors, and rather starting at ground zero, a lot of the time where there's energy, time, money thrown at that. One of my greatest pleasures, apart from sometimes being this constant 24-hour news a day sort of bad news, it's that actually there's so much sharing that can go on, and we all benefit. It really is a win-win thing. So it's very interesting and fascinating this afternoon to be hearing all this sharing and the commonality actually that exists and the influence that exists.
Sorry, can I just add as well?
Yes.
I mean, the other influence as well in that respect is through the UK's membership and UK judges attending the European Judicial Training Network, which is
And
well
I think also
established.
the European Network of Councils for the Judiciary, where the councils in England, Wales, Scotland, and Northern Ireland play a very active role. The main trainers.
Yeah, no, exactly. So it's that communication, the exchange of views, ideas, etc., through forums like that. Yeah.
And like this. Thank you to the Instituto. Sir, you wanted. Can you just say your name and who your question? Just a moment. Not while I'm speaking. Just so we can hear your name, which we would like to hear.
Stuart.
And Stuart. And who you're addressing your question to. And if you could remember, you've got a lovely big voice over there.
Two observations, but I'd like to just take up your last observation. Do you mind if I call you by your first name?
No, it's
easier than full name each time. I think the pressure is because of the backlog of cases in the High Court. A lot of cases, High Court cases, are transferred to circuit judges, particularly at Central London County Court, Queen's Building, and depending on the competence of the County Court judge, who deals non-stop with, in effect, High Court cases, it's a natural progression that they should go to the High Court, and I think that has an influence.
I can certainly see that as an influence as well. The increasing amount of what we
Pressure
historically have called high court work.
Because I mean, the workload now is the average workload is 2 years before you get to actual trial. But really, my point was to be made to Geordie about Roman law. I don't think you realise just how much, or maybe you do, it has influenced English law. Because, you know, we have two professions in this country, solicitors who do a very hard exam called accounts so they can get a lot of money on clients, and secondly, barristers, I see this much, and secondly, barristers who are slightly more interested in the law, and therefore, until, I don't know when, but John may be able to help us, he's a professor, they abolished it. All barristers had to pass an exam called Roman law, every aspect of Roman law, certainly until, I think, the 90s.
I actually don't know. I'm sorry.
I'm sure.
Thank you for that clear answer.
I'm sure. Sorry. And it was quite common in court then that you'd use Roman expression. Mind you, you didn't have to have a huge knowledge of Latin, as much as this lady here is learning Spanish upstairs. That would do. But certainly there was a lot more maxims used in the High Court, for instance. Nowadays, once it was abolished, I think it was an awful thing. No new barrister, I think from 2000 onwards, can say a word of Latin. But in the past, there was quite a repertoire of Latin in the courts. I mean, if I told a modern judge or barrister, re ipsa loquit, he'd think I was talking Mandarin.
So Stuart, thank you very much indeed for pointing that out. I think this is probably an interesting point just to say again to the Instituto is, I hope I'm not revealing something out of turn, but they are thinking, is my understanding, about offering Latin courses. Would anybody in this room, just as a matter of interest, be interested in a Latin course?
Let's go for a discount.
Yes, anyway, if you know somebody who is, it might be worth having him for word. Stuart, thank you very much indeed for that.
There's
And-
one other point.
Oh, go ahead quickly, I do want to let
This is
other people.
actually to Louise. Louise, you mentioned that you come here as an expert and the judge listens to what the law is in Spain and takes your advice. But that's always happened. I went to the Arias Pagos because in England, in criminal law, we have a system called specimen counts. For instance, it involved actually the EU, a fraud on the EU by a member of the Greek government who was cheating the EU on import-export taxes. So there were about 200 counts. But in England, the prosecution are allowed to say just 20 or 12 counts, their strongest counts. And if the defendant gets off with that, that means the other counts he or she would definitely get off. I went to the Arias Pagos because they didn't have that system in
So your
Greece.
question is?
No, I'm just saying. And had to explain to the Greek court that the fact that my client was acquitted on the 20 counts in England meant she couldn't be charged with the other 180 that the Greek court brought. And the Arias Pagos accepted that argument. Well, you know the Arias Pagos.
No.
Oh, it's the Greek Supreme Court. It used to sit in the Acropolis. Originally.
Aeropagos.
Sorry.
There we go. Right. Anybody?
May I?
Oui,
May I?
Estelle.
I had an observation. It's very interesting because we talk about backlog, and also in France, which we have a very different system from the common law, we have a huge backlog. And I think both English court and French court try to develop all the alternative dispute resolution, and this is very interesting from the judge point of view, especially on the continental law, because we talk about an active judge or the quiet judge, and sometimes, well, for French judges, they don't know really the place in their alternative dispute rule, especially if it's the case management stage, if the court has already been seized. And I think this is things that we really want to develop. We want to develop more, and maybe we also looking at your Article 36 of the Civil Procedure Rule to have like more coercitive, I may say, coercitive ways to accept alternative resolution. So yeah, I would like really to highlight that the question of backlog, I think is not really linked to a system, but it's because it's
It's not linked to the system. In fact, if they got rid of so much discovery and all these other things, they just went forward, everything came out once and for all, there wouldn't be a backlog, but of course we have this wonderful system which John has explained to everyone.
Thank you very much, Stuart. Very interesting to hear, Estelle, that what you're just saying about the backlog. Geordie, you wanted to add something?
Yeah, just a couple of words about what you said. Is of course English law still makes a difference between procurator and advocatum. So solicitor, barrister, and solicitor, and well, they were doing the same thing as they do in English law. This is true. But one of the things that wasn't said here up to now is that maybe one of the most important differences between continental systems and English systems is that English system is really based on trust in judges, and in the continent, I don't want to say what I think is and what you are really assuming, but we don't really rely on judges because we want them to follow the proceeding as it is established in the
There's
law.
a very good reason for that.
Yes.
So because 90% of judges come from barristers, and they
That's
first
it,
of all
that's
they
it,
have a
that's it.
standard, and secondly they've been at the bar for minimum 12, 14 years before they are even considered for a seat for district judge level.
And you see it when you see the laws in England and in France and in Spain. Well, we try to make them very precise, just to give the judge the path to follow, the exact path to follow. Instead, in England, well, you have kind of many possibilities for the judge to do this, to do the other thing. We don't have such a thing like this in continental Europe, even in this thing of substantive case management. It means, it really means that judges can, on its own motion, promote some evidence. But we don't all really have this. This is something very from German and Austrian law, more than the other countries. But these rules that you were saying were very influenced by a German guy. So, I mean, he tried to show how the system in Germany was, no? But it's not really this way in our countries because of the lack of trust in the judges. That's it.
And as you go further east, there's even less.
So it's interesting, so it's underlining what we're exploring there is the fact that English judges have more leeway, they have more discretion. Interesting. Yeah, it's so interesting to hear that. Any comments or questions? Yes, sir. Yeah.
Hello.
Tell us your name and who you're.
Rafael Miguel, the UK correspondent for Paris. Thank you all for all your expositions, they were wonderful. I have a follow-up question regarding Jose Miguel's question. I'm not very interested in the way that the judges are, the way they enter into the judicial career, but how they see themselves here in England. Because in Spain, they form part of the public debate. They have their own associations with different political tendencies, and they are a strong part of the political debate. I think here in England they're much more, I would say, humble or hidden.
Restrained.
Am I right? Am I wrong with that?
Well,
I'm not sure how humility was it.
I'm not going to comment on humility.
Of course.
That's very much an individual difference, isn't it? Where individuals are concerned. Sometimes you can see judges refer to themselves, and particularly Supreme Court justices have been known to do this, refer to themselves as the guardian of the rule of law or guardians of the Constitution. You know, I mean, those type of expressions in terms of their role, particularly for Supreme Courts justices, you sometimes hear that. In terms of politics, judges here aren't allowed to engage in politics at all. The guidance on judicial conduct is very clear that judges are not allowed to make political comments, not allowed to engage in politics. Historically, that wasn't the case. I mean, historically, our judges not only sat in the House of Lords at one point, our judges were speakers of the House of Commons as well as speakers of the House of Lords at one point in time. It wasn't until I think the 1880s that our judges were prohibited from being members of Parliament, so MPs. So there was engagement in politics at one point, but as the 1900s went on, you saw the removal completely of the judiciary from formal politics in terms of being members of the legislature, and that of course was crystallised in 2005 with the Constitutional Reform Act, which first of all removed sitting judges from the House of Lords, so no more law lords making statements in the legislature in terms of political statements. I'm not talking about their judicial powers. And equally, the Lord Chancellor lost the role that office and had of being a judge as well as a member of the executive as well as a member of the legislature. So both formally, there is a separation of the judiciary from the political branches of government, but also in terms of taking part in debate, in the speeches that judges give, they're not allowed to make comments on politics or enter into political debate.
May I add another
Yes, go on.
question? Professor Carreras said that he, in some sense, experienced.
Can you speak slightly louder so everybody can hear you? Thank you.
Professor Carreras said that he experienced in some of the procedures that he witnessed here that justice was being made in the process. I mean, and that you were witnessing justice being made. I also have felt the same covering some cases here, because in Spain, I have the perception that because of the restriction that law applies to the judges, as Professor Mira said, you have the perception that they already made up the mind. But just in case they're going to listen through the procedure, in case there's something new, and they change their mind. But their mind is already made up from the very beginning. And here, I have the sense that judges really listen to both sides and ask for arguments, ask for precedents, ask for laws or statutes. I mean, they're developing their own judgment during the whole process. Would you agree with that?
Yes, but after I left, I thought to myself, maybe I had to explain, and you give me the opportunity to explain a bit better about it. Because from some people, what I've said would diminish the quality of our justice, or the system of justice. It is not what I meant. But I was trying to say that when you say something in general, you are unfair with the minority always. So there's a lot of good judges in Spain, don't mistake that. But it is true, on the one hand, one as a lawyer, practicing lawyer, tends to think that this particular judge today, he was already decided.
Yeah.
And sometimes you feel that you are, as a lawyer, you are a burden, that you are a nuisance, that the judge has to listen to you. The law should be made more wiser, and then, come on, let's get rid of lawyers and let's make justice. But that's a minority, I would say, minority. But if I have to generalize, I repeat what I said. The sense of justice here appeals to me more. Maybe because here, when I worked, I am an expert, therefore I'm not a lawyer or one of the parties. So when I read the judgment, I'm more impartial because I'm not the client who's won is not my client. Maybe he's the one who paid me, but I'm not his lawyer. I'm just an expert, you know. So my detachment from the case is bigger than when I lose a case when I litigate in Spain. So maybe my tendency to feel unfairly treated, let's say, in my country, it's bigger than here for sure.
Sorry, you got more exposure in that sense.
Yeah, because the case is a bit like your son, you know, and then you
Or
have
your daughter.
or your daughter. You have nurture it, and then you expect it to be grown up and successful, and then you lose, and then that's bad news.
Yes, Esther. On your first remark, and I don't think we have talked about this, but I think it's very important also that in common law and the UK legal system, you also have a legal dissident opinion, and the judges, the name of the judges is really engaged in the decision is making.
That's
And
bad, yeah.
under civil law system, well, I don't know in Spain, but for France, you will have the name, or you would never say I judges. It would be just like the judge, like we say the mouth of the law. So the judges are hidden behind the law. So it's maybe not question of political, but I think the image of the judges in the UK may be more important or more visible for the litigants than in a civil law system.
Well, maybe I didn't express myself well. What I meant is that in Spain, for instance, you have different judges association with different political tendencies,
Speak
and
more.
they tend to participate in the public debate too much sometimes.
I think we could have inferred that from your question, or certainly that's what I thought you meant. Yes, John, and then I'm going to Geordie. Yeah.
Okay, there are judicial associations here as well. So there's one for the High Court judges, one for circuit judges. There's the Magistrates Association, but again, they don't take political stances. They're there to represent the interests of the judiciary in a broad sense. I'll leave it like that. Not politics, but not politics.
And I'm sure you can get judges who get up on the wrong side of the bed
Should
everywhere.
in every profession, that's true. Whether you're a dustman, a journalist, or whatever you are, one can get out on the wrong side of the bed. But of course, if you're a judge, possibly it has more consequences. Geordie.
Yes, just one brief question. One of the reasons why Luis was saying that he feels that judges here in Britain are more engaged with the justice of the case, maybe it's because of the pre-trial phase, because they tend to speak very directly between lawyers and judges. This is exceptional in Spain, or if it happens, it happens privately.
Yeah.
So here in the pre-trial phase, there are none of these big speeches that you hear in a Spanish process. One speaks, the other speaks, and no one says anything else. But there is a real debate, so it makes you a bigger engagement with the justice of the case. I think so, and I completely agree with you. With the political tendency of some judges in Spain, I also have to say that I think it's a real little minority who do that. But the problem is that some of them are situated in big responsibilities. So they had to keep silent in political matters, but they don't. And I regret that really, because it is really against all international soft law or recommendations of the European Council, and they ignore that, even if they know that. And I think this is really bad for Spanish justice.
It's interesting. It would be interesting to see some sort of survey evaluating how this colours influences the population and their trust in the judiciary in that way. So it's very interesting to hear you. Thank you for your very interesting questions and also the panel's responses. If there is a burning question, I'm happy to take it, but if not, I'd like to move.
Short comments from the audience online.
Yes, please.
There are
Thank you,
comments,
Victor.
not questions. One is a regret, I think that I agree with, because it's our fault, that we are talking about English law instead Anglo-Welsh law.
I did say England.
You said
You said
that's why it's my fault. That's why I say it's my fault, because we chose the title. So this is Miriam online. So thank you, Miriam.
Thank you for that comment.
You are right. And Jeffrey, he makes a long comment, but I will say some brief part. I remember giving a presentation of the EFBA, European Bars Federation, some years before 2016, when separation was still but a dream in the minds of the Brexit exceptionalists, and I made a demonstration by holding up a European rounded 2-pin plug and a UK square 3-pin plug, both efficient in their own right, and then putting them together with a simple adapter.
What's his name?
It's Jeffrey.
Well, thank you, Jeffrey.
Jeffrey Forrest.
I'm all for very straight examples, and another analogy could be, it's wonderful to have a bulb and a lamp. It's wonderful to have a socket, but if the bulb doesn't meet the socket, it ain't happening. So I think a lot did happen, and that was down to your very good choice of the panel. Let's have some closing remarks. I'd like to invite Oliver Chapman, who is from the Law Society of England and Wales International, and you're a policy advisor for them, for Europe and the Commonwealth of Independent States. Is that right?
That's right, although we call it Central Asia these days, it's a bit outdated to call it reverse the
Then let's go for Central Asia.
Thank you. So, buenos dias, bonjour, and hello to everybody. As I stand up here, I'm very aware that I'm the last barrier between you and the weekend, so I as brief as possible. So first of all, I'd like to go for a round of thanks. Thanks first of all to the Instituto Cervantes for organising this and for hosting us here. Thank you to the French and Spanish embassies for joining us and supporting this event, as well as the BSLA and many more that I forget. Thank you to the speakers for their very interesting presentations and contributions to the debate. Thank you to our moderator. And thank you all very much for attending on a Friday afternoon. It's certainly impressive that this event has sold out on a Friday afternoon. I have seen my fair share of empty rooms at such a time, and I think that that is a testament to the quality of the speakers and presentations. I hope that you all enjoyed these discussions as much as I did. While certain comparisons between continental and common law systems are not new, they are certainly more relevant than ever today in the context of Brexit. These comparisons help us to realize why our systems seem so different. They help us to realize that while our systems seem so different at a glance, they are in fact very similar. I can remember discovering that, as was repeated earlier just now, after having been told for a very long time that judicial precedents are a quirk of common law, that continental judges often tend to follow the decisions of higher courts, but I'm sure that Jose and Estelle can comment more about that than I can. Seeing how close our systems are helps us to understand how lawyers can cooperate and work together. Since Brexit, UK lawyers no longer benefit from EU directives covering lawyers. They now have to grapple with 27 different regimes for accessing legal practice around Europe. Events like this serve to remind us of the common ground and help us build bonds across borders. Fortunately, our continental counterparts have been very open and friendly, and we maintained excellent relationships with them, which has helped to smooth the transition period. For those of you who are not aware, the Law Society's international team works not only to support UK lawyers and law firms working abroad, but also to support Spanish, French, and other international lawyers working here. We do so not only by providing guidance, but also by arguing with government and regulators to ensure that the UK remains an open jurisdiction. We are very proud that the UK is an open jurisdiction, where lawyers from all over the world can come and practice under their home title. They can give advice on their law of their home jurisdiction, they can give advice on public international law, EU law, and many elements of English law. This is what has allowed London to be a leader in the international legal services and the home to a truly diverse legal community. For those ambitious lawyers who wish to requalify as solicitors, the Solicitors Qualification Examinations, or SQE, provide a direct route to the profession. Lawyers with recognised qualifications and experience gained in their home countries, including in France and Spain, can obtain an individual exemption to the second part of the exam. This would leave them only having to pass the two first exams, which covered knowledge on English law. I know of at least one person who is here today who is going through that endeavour at the moment, and I encourage all of you who have not yet done so to join them in doing so. On that note, I will let you go. I hope that you will stay for a drink after this, and I would hope to be able to speak with some of you afterwards. Thank you.
Thank you very much to you. I'm the next barrier, just between you and the drink and the weekend. Thank you so much to you for asking me to chair this. I've learned so much. I feel like I've got all kinds of questions. Highly impressed. I knew by speaking to you beforehand that I'd learned a lot, and I did. I hope you all feel you did too. So thank you to the Instituto Cervantes. Thank you to you joining us online very much. I should mention that this has been recorded, not just been streamed live, and will be put on the Instituto's website, so you can on YouTube, beg your pardon, on YouTube. So very clear it'll be on YouTube if you wish to watch it. In case you caught us a little bit late, you can have the pleasure of watching it all over again, as many times as you like on YouTube. So from this Paul, we're going to say thank you very much indeed to our eminent speakers. Please help me to thank. Thank you. Muchísimas gracias.